Welcome to The Explainer. Today we're diving into something really important, Article 27 of the EU's landmark AI Act. You can think of it as a brand new shield, one designed to protect our fundamental human rights in this new age of automated decisions. So let's start with a pretty big question. Think about it for a second. Could an AI decide your future? It's not science fiction anymore. Whether we realize it or not, these systems are already making calls that affect our lives, our opportunities, our whole future. I'm talking about the big stuff, right? When you're applying for a job, trying to get a loan, or even accessing social benefits, there's a really good chance an AI is involved somewhere in that process. And in these high-stakes situations, the consequences of the system getting it wrong, well, they're enormous. So what's the EU's game plan for handling these massive risks? It's not about waiting for something to break and then trying to fix it. Nope. They're introducing something really powerful, a way to protect people before an AI system is even switched on. It's called the Fundamental Rights Impact Assessment, or FRIA for short. The best way to think about it is like a mandatory pre-flight check, but for human rights. Before a high-risk AI system can take off, you have to run this assessment. It forces everyone to just pause and really think about the potential for harm. And look, this isn't some vague, please be ethical suggestion. The FRIA is super specific. It's got 6 core requirements, a clear, structured checklist. Anyone who wants to use one of these high-risk systems has to go through it step by step, from what are you going to do with it, all the way to what's your plan for when it messes up. Okay, so that's the theory, but what does this actually look like in the real world? Let's make this concrete. We're going to walk through an example to see how this FRIA checklist really works. All right, let's imagine a local government office. They decide to use a new AI system to sort through applications for public housing benefits. This is a classic high-risk scenario, right? Because the AI is making a huge, life-changing decision about someone's access to a basic need. So one of the first and most critical steps is to ask, who could get hurt by this? The deployer has to identify the people most likely to be affected. And this is so important because we've seen it time and time again. If you're not careful, AI can just take existing biases in society and crank them up to 11. Next, you have to get really specific about the potential harms. For example, what if the AI was trained on 20 years of historical data? What if that data reflects old, biased housing patterns? Well, the AI could learn that bias and start automatically rejecting perfectly good applicants from a certain neighborhood. That's straight-up discrimination. But here's the key part. The FRIA isn't just about listing all the things that could go wrong. It forces you to come up with solutions before you launch. So you might decide, okay, a human being will always make the final decision, or we'll set up a simple, clear appeals process so people can challenge the AI's call. It's about building those safety nets from day one. When you step back, you realize this whole process is a huge change in mindset. It's a fundamental shift in how we regulate technology. We're moving from being the cleanup crew that shows up after an accident to being the engineers that design a safer car in the first place. And you can actually see this evolution right in the legal documents. The first draft back in 2021 was pretty reactive. It basically said, hey, just keep an eye on these things once they're running. But fast forward to 2024, and the final version is way stronger. It demands this proactive, before-you-launch assessment. And this chart just lays it out perfectly, right? We're going from the old way, monitor and report, to the new way, assess and prevent. The whole focus is shifting. It's not just about making sure the tech works, it's about making sure it works for people and protects their fundamental rights. And this quote here just nails it. The focus isn't only on the tech anymore. It's about safeguarding rights through proactive assessment. That's the whole idea in a nutshell. It's a powerful statement that says, hey, with great technological power comes great responsibility to protect people. So, what's the bottom line? What do you really need to take away from all this about Article 27 and this FRIA? I think the big takeaway is this. The FRIA is trying to weave human rights into the very DNA of the technology from the very beginning. It's pushing this idea of human rights by design, and that's a huge deal. It's the foundation for building AI we can actually trust, and it really sets a new global standard for accountability. Now, it's important to know this doesn't apply to every single AI out there. It's really targeted. We're talking about government agencies, private companies that provide public services, and those high-stakes industries like insurance and banking.
The law is focused on where the potential for harm to a person is the greatest.
And get this, it's not a one-and-done thing that you just file and forget. The law says you have to keep these FRIA records for at least 10 years. That creates a paper trail, right? It means there's a decade of accountability built right into the system. So the FRAI is, without a doubt, a huge leap forward. But it does leave us with one final and really important question. You can have the best checklist in the world, but is that enough to truly guarantee ethical AI? The real test isn't going to be the law itself, but how it's used, and whether this human rights shield is actually strong enough to protect us when it matters most.